Good evening and welcome to the Planning Commission meeting Monday, June 12th, 2023. Iris, will you please call the roll?
Leak is excused. Stewart?
Here.
Heap?
Here.
Mitchell?
Here.
Moreno?
Here.
Phillips is excused. Miles, Rigby.
Here.
Thank you. Next on the agenda, we have a council update, but with Councilor Afghan not able to join us this evening, we'll move on to public comment for issues not on tonight's agenda. Iris, do we have anybody who would wish to speak?
No.
Okay, thank you. Moving on to the Commission for Citizen Involvement. I personally don't have any updates. Does any of the other commissioners? No. Staff? No. Seeing none, we'll move on to minutes. First set of minutes I'd like to look at are from April 24th, 2023. Is there any discussion, or would somebody like to make a motion?
I move to approve the minutes. Second.
Okay, we have a motion and a second. All those in favor say aye.
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 Any opposed? Any abstain? All right, motion carries.
Who seconded the motion?
I did.
Thank you.
Moving on to the minutes of May 22nd, 2023. Commissioner Heap, you had a comment?
Oh, yes, I asked staff to add comment, which was reflected on page 2 in our meeting minutes that were handed out tonight, lines 13 to 14. My comment was to reference that it was actually a U.S. Census Bureau report that I was referencing, so it's official U.S. Census Bureau data. There was a little bit more that was added in addition to that. It talks about Mr. Wilson cautioned against using data collected during recent years to reach conclusions during the pandemic. I don't remember that, but I trust staff looked at that, it was accurate. And then it also mentions Chair Leak responded she didn't expect to see a decrease in the population in Lake Oswego in future years. I didn't remember that. What I thought I remembered Chair Leak saying was that people were moving from Multnomah County that had issues into Lake Oswego. And my only request was to show that it was the U.S. Census Bureau, so that people are reading the minutes, they can go out and see for themselves that Lake Oswego had a 1.1% decrease from 2021 to 2022, and Portland area had a decrease of 8,308. So my only request was to add the U.S. Census Bureau. I don't mind keeping the rest of it if we could just give a reference, so if folks want to go out there, they can look at the Census Bureau's U.S. Census data and take a look at it for themselves. And it doesn't have to be a hyperlink. I'm just saying, just mention U.S. Census Bureau.
We can't do that. But the one thing I would just mention is that based on the meeting record, I'm just sort of reflecting. I went through and actually listened to the meeting record for that portion, and this reflects what was said at that time.
Okay.
The reason that I didn't put the U.S. Census is because there are different types of U.S. Census. The one that we depend on is the decennial census. So that's the one that 10 years, every 10 years, it's done a pretty major update to the census. So when we start talking about ACS data and things like that, referring to that as U.S. Census data, I thought that was a little bit too confusing and wasn't something that we actually mentioned during that period of time. So I did think that it would be a little bit confusing to mention the U.S. Census, given that we would have to make a lot of clarifications.
And I would like just to have full transparency to the public, and rather than throw data out there, just state where I'm getting it from. It's from our U.S. government, and it's the U.S. Census Bureau.
We can add that to the record.
Yes, thank you.
Yeah, we can add that to the record, but it just wouldn't necessarily make sense for the minutes, unfortunately.
I would
We can add it
object
to
and
the
say that
minutes
I
for
wanted
this
to add it
meeting.
to the minutes.
And all the clarifications, of course, about just putting this on the record. The reason that we wouldn't consider those data is because it's ACS data based on 2-year collections, and it was something that is something that we don't typically use for the housing needs analysis. We, again, depend on population forecasting from Portland State University as well as the bicentennial census.
The question is what was said at the prior meeting? What was
Yes.
said at the prior meeting? In this meeting's minutes, we now have all this discussion about the US data, US Census stuff, so that'll be available to the public.
Well, I believe maybe what Mr. Heap is saying is that he said at this meeting of which we're speaking that the data was from the US Census Bureau. Is that correct?
To be honest, I may not directly said the U.S. Census Bureau, but that's what I was referring to.
I see.
The person who had responded from the public had mentioned the US Census, so it was kind of the topic of discussion at that time, but it wasn't stated.
All right, well, with that being said, would somebody like to make a motion on these minutes? Motion, is there a second?
A second.
Discussion on the motion?
What's that?
Discussion on the motion?
Yes.
Just to be clear
discussion.
here, was the motion to approve the minutes as was amended today in our handout? Or was the motion to approve the minutes as they were originally distributed to us in email?
Make the motion to approve the minutes as amended and presented to us today.
Thank you.
Any other discussion? Okay, I'm gonna, Iris, could you call roll on this one?
Lee, Stewart,
Abstain, I was not at the meeting.
Heap,
No, I feel like it's presenting matters of opinion and not exactly what was said.
Mitchell,
I approve.
Moreno,
Approve.
Rigby.
I approve.
All right, motion carries. All right, moving on to our public hearing this evening on psilocybin time, place, and manner regulations. Public testimony is accepted at this public hearing. Do we want to make a statement?
I'll go through the process, and then I think Ms. Namalu will go through the staff
Sounds
report.
good.
And before I start on that, Iris, is there anybody in the virtual world? All right, and for the record, I see nobody in the audience. So this is a legislative decision, which is generally a policy decision within the discretion of the City Council. Planning Commission will review the legislative proposal and make a recommendation to the City Council. Although a legislative decision may be discretionary, it must also comply with any applicable state law as well as the applicable statewide planning goal or administrative rule adopted pursuant to ORS Chapter 197. A legislative amendment to the Community Development Code must also comply with any applicable provision of the Lake Oswego Conference Plan. The public hearing process will begin with a presentation by staff, and since there's no public testimony, I won't go through the time limits for public testimony in the order. At this point, I would ask the commission members to please declare if you have any financial conflicts of interest to declare. Seeing none, then Interim Community Planning Director Namalu with the staff report, please.
Thank you, Mr. Boone. Good evening, Vice Chair Stewart and Commissioners. I am the project coordinator for the draft code amendments on psilocybin time, place, and manner regulations. And the presentation tonight, I'll provide a brief background, go over general purpose and objectives of the draft code amendments, discuss the code concepts that were advanced by the Commission at your last study session, and then provide an overview of the draft psilocybin code amendments that were included in the draft amendments forwarded to you tonight. So for the background, as you know, Measure 109, which is codified in ORS 475.A and OAR Chapter 333, it legalizes and regulates and taxes the manufacture, sale, and administration of psilocybin for mental health purposes and directs the Oregon Health Authority, which I'll refer to as OHA going forward, to license and regulate psilocybin products and the provision of psilocybin services. The City Council did enact a temporary ban on psilocybin facilities at the end of 2022, in December of 2022, and directed the Planning Commission to develop time, place, and manner regulations. And the banning ordinance has to be referred to voters at the next statewide election, which would be in 2024, if the City Council does not adopt regulations allowing psilocybin service centers and manufacturers in the city, or does not repeal the ban. Since the ban was imposed by the City Council, the Planning Commission has had 3 public work sessions in January, February, and April of this year. At those study sessions, they first introduced the topic, provided some background and a work plan. You had an expert panel to answer questions about psilocybin use. And then at the last study session on April 24th, you discussed code concepts that had been drafted by staff based on feedback from both the Commission and the City Council. The state statute does allow cities to adopt quote-unquote reasonable regulations, and the statute does outline what those reasonable regulations may be, and it relates to manner of manufacturing of psilocybin, manner of providing psilocybin services, limitations on hours of operations, requirements related to public access to a premises, and of course, reasonable limitations on where premises may be located. The overall purpose of the code amendments is, of course, first and foremost to protect public health and safety. And this would include providing buffers from psilocybin facilities where children congregate. So these would be the provisions for buffers from schools and daycare centers. And then, of course, to implement the comprehensive plan. The objectives are to prepare for the possibility that the City Council repeals or voters overturn Lake Oswego's temporary ban on psilocybin facilities, and to make sure that we have time, place, and manner regulations adopted in the CDC in the event that that were to occur. If we don't do that, then the OHA regulations would, of course, apply. And then as far as the CDC regulations that would apply, it would be any existing regulations that would apply uses that would be similar to what a psilocybin service center would be or a production facility. So for instance, a production facility may be similar to a light manufacturing use. So any of the regulations or zones that light manufacturing would be allowed, that's what we would apply if we didn't have any other standards in place in the CDC. And then finally, to comply with the statute in terms of what a reasonable regulation of psilocybin facilities is. At the April 24th work session, staff had presented a number of code concepts for the Commission's consideration to regulate psilocybin. And after considering all of the concepts, these concepts that are listed here are what the Commission directed staff to include in the draft amendments. And that would be specifying what zones the uses are allowed in, providing buffers from childcare facilities, providing separation from other psilocybin businesses, prohibiting psilocybin facilities in the same building as certain uses, which I'll go over in a little bit more detail here in a minute. Restrict access to anyone under 21, prohibit advertisement of psilocybin products visible to the general public, require release of clients to a sober adult, prohibit possession of weapons during treatment sessions, require liability insurance, and require all manufacturing and growing to occur in a fully enclosed building. At that study session, the Commission discussed whether some of these concepts were actually necessary. But you ultimately decided to include all of these in the draft amendments to allow public review and feedback at the hearing. I will note that to date, staff has not received any written comments from the public on the proposed amendments. Chair Leek, who could not be at the meeting tonight, did email all the commissioners and staffs her thoughts on the draft amendments, and that email I know you all received. We have also included it in the record for this application as Exhibit G1. And in that email, she stated that she supported approving psilocybin service centers and grow operations with a few caveats. One of them being that no service centers or production facilities should be allowed within 1,000 feet of licensed daycare center. And she said if the standard applied to elementary, middle, and high schools, it should also apply to licensed daycares as well. She also recommended only allowing a maximum of 5 licenses for service centers in the city within the first 3 years if an ordinance is adopted. And that after 3 years, the commission or the city should review how these centers are operating and evaluate if they should remain or if additional regulations are necessary. Staff did include the 1,000-foot buffer she recommended in the draft code amendments, so that's already in there. The provision to review the regulations in 3 years after adoption of an ordinance is included in the draft ordinance, which is in Exhibit A1. And then the commission can deliberate tonight and discuss whether to include Chair Leake's recommendation to restrict licensing to a maximum of 5 service centers in the city in the first 3 years. So now moving on to an overview of the regulations and starting with which zones the psilocybin facility should be permitted in. The draft code amendments would allow psilocybin services in all service centers, in all commercial zones, except in the NC, WLG, and OC and WLG RMU zones. The use would only be permitted as a conditional use. And that conditional use is a major development. It requires a public meeting. It requires a neighborhood meeting, first, and then a public hearing. And conditions could also be imposed that in order to make the functional characteristics of that use reasonably compatible with uses in the vicinity. And the reason why staff has included the provision as a conditional use in those zones is that those particular zones, their purpose is to provide lands that are for lower intensity commercial uses that are generally aimed at serving just the surrounding neighborhood, so kind of a smaller service area. For psilocybin production, which is not shown in the table here, the code amendments would only allow them in the industrial and industrial park zones, so that would be the Southwest Employment Area and the Foothills area. And the reason for that is that we don't know the potential impacts of this use because that use does not exist anywhere in the United States right now, or at least it hasn't been operating long enough to know. And we would expect, though, that the production use would be similar to the types of uses allowed in those industrial zones, which include light manufacturing, nursery stock production, and wholesale distribution. I would note that the draft amendments do prohibit both psilocybin service centers and production facilities in residential zones, and there's a specific provision that prohibits it as a home occupation. Moving on to buffers from schools and licensed daycare. I think as you're all aware, the minimum state requirements requires a 1,000-foot separation from service centers specifically to schools, and this includes public, private, or parochial elementary or secondary school. And it also prohibits service centers in zones that are zoned exclusively for residential use. Please note, though, that the buffer required by the state does not apply to production facilities. It's only to service centers. And the map you see here on the screen, it shows that 1,000-foot buffer that's just required by the state from schools. And you can see that the areas in red are commercial, industrial, or mixed zone lots where you could potentially site a psilocybin service center. Per the draft code amendments, production centers would only be allowed in the I or IP zone, which are, there we go, which would be in the Southwest Employment Area or in the Foothills area. The draft amendments actually includes, in addition to the 1,000-foot minimum state buffer requirement, it would include a 1,000 buffer from licensed child care facilities as well. And this map shows both buffers from schools and licensed child care facilities. And this would apply to both psilocybin service centers as well as production facilities. The areas in red here show where the potential locations of the service centers would be located in red. And then, of course, again, as I mentioned before, the production facilities would only be allowed in the I and IP zones. Because that map is a little hard to read, we'll kind of just zoom in here so we can see it a little bit closer. Starting in the Cruiseway corridor, you can see that the service centers would be allowed in the Center Point area, which is HC zoned, in the MC zoned area in the CRD. For reference, this is Cruise Way, if you can't read that. And there would also be one small area, which is next to the Yakima building in the OC zone, where a service center could potentially be allowed. In the Southwest Employment area, this is your IP zone, where you could allow production facilities or service centers. And then in the Westlake Grove area, WLG OC and WLG RMU, service centers would only be allowed as a conditional use, and a little pocket of neighborhood commercial where it would only be allowed as a conditional use as well. In Mountain Park, there's 2 neighborhood commercial areas that would require a conditional use permit to have a service center. And in the downtown area, you can see most of downtown would be inside the buffer. So the only areas in downtown are these 2 EC zoned areas. This is the car wash, and this is across from Sunderleaf Plaza, where a service center could be located. And then in the I zone, service center and a production facility could potentially be located. And then finally, in the Merrillhurst area, in the CI zone, you could potentially locate service centers there. The statute does specify that buffer to a school can be reduced to 500 feet when there is a, quote, physical or geographic barrier, but that is not defined in the statute. And so in the draft code amendments, we do specify that to qualify for that buffer reduction, that you would, the physical or geographic barrier would have to be something like a body of water, an interstate freeway, or something similar that a person could not walk across, and that a door, fence, or gate is not an acceptable physical barrier for that reduction. Moving on to separation from other psilocybin facilities, the state statute does permit a city to require a maximum separation of 1,000 feet between service centers only. It doesn't specify production facilities. Since the statute outright permits this separation, staff advised you at the last work session that the commission would not really need to come up with any findings or justification for this standard if you chose to adopt it, since it's included in the statute. But since it doesn't apply to production facilities, if you wanted to apply it to that, the commission should have some findings as to why that's a reasonable regulation and what the purpose of it would be. I do want to note that at the work session that this was one of the items that the commission had some discussion on, where there were some differing opinions as to whether or not this regulation should apply. The next regulation is prohibiting psilocybin facilities in the same building as certain uses, and those are the uses, I won't read them off, that are listed here up on the screen. And per the OHA regulations, what they require is that the interior and exterior areas of the psilocybin businesses can't overlap with any of the businesses. So for instance, you couldn't have a service center with like a food cart in it. But the draft amendments would go a little bit further, and it would prohibit both psilocybin service centers and production facilities from locating in the same building as any of those uses that are listed up on the screen. The code amendments would also include an exception that would prevent a situation where a licensed psilocybin facility legally located, it wasn't located in the same building as any of these uses, it met all the buffer requirements, and then a business later came in and located within the buffer area, say a daycare center came in and located too close, or a restaurant located in the same building. We wouldn't penalize that business. They've already located there. They were legal at the time. And if another business chooses to locate there, then there would be an exception that wouldn't require that or now make that existing psilocybin business illegal. Again, this is another item where the commission had differing opinions at the last study session. At the April 24th work session, staff had advised the commission that it wasn't clear in the state rules whether interpreters or support persons who are permitted to attend client admin sessions must also be required to be 21 years of age. However, upon closer review, it clearly states that no one under the age of 21 can work or be on the premises, which is what I missed when I looked at it earlier, in a psilocybin facility, excuse me. There are exemptions for OHA or local government officials. So for instance, a local police officer could respond on the scene if they were less than 21 years of age. I still have included this provision in the draft code amendments as directed by the commission, but I did want to note that since it is already covered by the state rules, it could potentially be omitted if the commission so desires. Advertisement of psilocybin products. So state rules don't prohibit the advertisement of psilocybin products, but it does establish restrictions that aims advertising at folks or kids that are under the age of 21. So things like cartoon images would not be allowed for advertising psilocybin products. And the restriction that's in the proposed draft amendments would prohibit advertisement of psilocybin products that are directed to the general public, so window signs, banners, that type of thing. However, I do want to note it would not apply to any sort of advertising within the building itself to clients, directly to clients, or it would not apply to the main exterior sign for the business. This is another one, again, that there were differing opinions on the commission as to whether this should be required. And then these last four regulations are all included in the draft amendments, requiring clients to be released into the care of a sober adult after an admin session, prohibiting clients from bringing or possessing any weapons or firearms on the premises during the treatment session, requiring liability insurance, and requiring all manufacturing and growing to occur in a fully enclosed building. These are regulations that the commission didn't have any particular issue or discussion with, or at least they didn't raise them at the last work session. Certainly you can have more discussion about it today, but I won't go into detail on those because those are pretty straightforward. So I want to just provide a recap of all the regulations that apply to service centers and all the regulations that apply to the production facilities. These two slides that I show you may be helpful in your discussion as just a summary list of the regulations that you might use to lead your discussion. So in terms of regulations for service centers, prohibit the use in residential zones and as a home occupation. Require a 1,000-foot buffer from registered childcare facilities and between other psilocybin service centers or production facilities. This would be in addition to the 1,000-foot buffer required by the state from schools. Prohibit any psilocybin facility from being in the same building as the uses listed here up on the screen. Require clients to be released to a sober adult after an admin session. Require all persons present in an admin session to be at least 21 years of age. This is one you could potentially omit. Prohibit clients from bringing or possessing weapons during an admin session. Prohibit advertising of psilocybin products directed to the general public visible outside the building, and require liability insurance. And the asterisks are just the regulations that the commission had differing opinions on at the last study session. And then recap for production facilities. Again, like service centers, prohibit the use in residential zones and as a home occupation. Require a 1,000-foot buffer from registered childcare facilities and between other psilocybin service centers or production facilities, again, in addition to the 1,000-foot buffer from schools. Prohibit the facility from being in the same building as the businesses listed here. Require all manufacturing growing to occur in a fully enclosed building, and then require liability insurance. And finally, as I mentioned before, at the April 24th work session, the commission directed staff to include a provision in the ordinance stating an intention to review the adopted psilocybin regulations 3 years from the effective date of the ordinance. It wasn't really appropriate to include that as an actual regulation in the CDC, so we did include it in the ordinance, which is in Exhibit A1. I do want to note that the city could always review the code sooner than 3 years if they so chose. And, but by stating it in the ordinance, it does put the public, or provide some assurance to the public that we will be looking at this again and may adopt additional regulations if we find that there are impacts that warrant that. And it also provides advance notices to any psilocybin businesses considering locating in Lake Oswego that a future review is scheduled to occur. The staff recommendation is to either approve the public hearing version of the code amendments presented to you tonight or approve the code amendments with modifications. Once the commission has made a decision, there is a public hearing scheduled before the council. Right now, it's scheduled on July 18th. I do want to note that there are, this was discussed in the staff report, there are some regulations or restrictions that are not land use restrictions that are included in the draft ordinance, or I'm sorry, draft code amendments. And those that are not land use restrictions will need to be separated out into a separate ordinance from the land use restrictions. An example of a non-land use restriction is requiring liability insurance, for example. And so what will happen is once the commission has made a tentative decision, staff will separate those out and you will make a formal recommendation on the land use portion of it to the city council and then make an informal recommendation to the council on the non-land use restrictions ordinance. And that concludes my presentation to the council. I'd be happy to, or to the commission, excuse me, and I'd be happy to answer any questions before, I guess there's no public comment and deliberations.
Thank you very much. Any questions for staff?
Thanks, Jessica. This was a great presentation and really walked us through the history and how we got here and all the sessions we've had here. I just had, I guess, a couple of questions, and I think I probably previewed them last time we discussed it. And my first one was the restriction around buildings that have restaurants in them. And I guess my first question was, are we defining building? And based on the proposal, it didn't look like we defined buildings. I'm not sure if we go to like the common definition in the code. But I'm thinking of a strip mall that has, 25 businesses and one of them happens to be a pizza place on the end. Based on the way it's currently drafted, would that all was in the same quote unquote building and therefore this restriction would apply?
Yeah, I think it would. And I did mention that at the work session that, so for instance, in the mixed commerce zone, which is out by Bangi Road, there's a large strip mall. So I think that would be a perfect example where that is technically one building. And so you could, even though they may be located at opposite ends, it would not be allowed because it would be in the same building.
Okay. Yeah, and then when I'm looking at the map, which is...
If I can just interject, I'm sorry,
sure.
just for the record, these amendments that are the land use part would be included part of Chapter 50, and definition of buildings and the definitions that are found in Chapter 50 would apply. So building is a defined term. It refers to a structure, and yes, Jessica's right, it would take the whole thing because the walls that are within a strip mall, move type of thing. So it's all within the exterior walls.
Mm-hmm. I get, the question I'm getting to is when I'm looking at the map and the radius restrictions, and then we add licensed daycare, now, we have just a few, there's just a few spots that really would work. And I don't know the answer to this, but I don't know when you're looking at those red spots, how many of those red spots have strip malls that have restaurants in them? Are we effectively narrowing this down to just like really no options or very few options? I don't expect to have an answer. I don't, because I don't expect anyone to go through all those red spots and see how many strip malls are there. But it was just a thought that I had because I understand the other restrictions, liquor business, marijuana business, but to me, the restaurant one just seems out of place. And especially if you count what is going to be the effect at the end of the day, which is knocking out a whole bunch of more options.
I mean, the commission could certainly say, 50 feet. I mean, it could, for this purpose, could define a distance within this one. Like, if it's within the same building but more than 50 feet away, it shall not be considered, for purpose of this regulation, to be within the same building.
I guess my question would be to Jessica and the rest of the commissioners, do we share the same concerns for restaurants that we do for another marijuana business, another liquor business, et cetera?
Well, we're starting to deliberate, so maybe just ask questions, and then we can kind of come back to that.
Yeah, okay.
Probably be best. Did you have another question?
That was my first question.
Okay, go ahead.
I'll keep going, I'm on the spot here. The second question was advertising. And again, I think I previewed this the last time we talked. And I understand, no advertising to the minor, that's in the state statute, and I understand the analog to tobacco products, et cetera, but I'm wondering how we define products, because I'm wondering how this plays out. If somebody walking by, do they know that's a service center? Somebody that has no idea it's there, walks by, it's like, oh, there's a psilocybin service center. Is there any way to identify it that way so that they know they could walk in and ask questions? So if the definition of product is so huge that there's no way to allow a walk-by customer to see that that's what that place is, then I'm just wondering if that's gone a little bit overboard in the advertising bin. And again, the analog to me is dispensaries, which I think have sort of, the market they've gotten around it through the market because they have a green cross that, technically is not advertising a marijuana product, but everyone now understands from the market perspective that that's what that is. It's not really a question, it's sort of a thought on, I just want to make sure we're not restricting if we're going to allow these businesses and they're going to be there, I want to make sure that they can effectively get a customer base in there. And that's what I'm wondering.
Well, certainly the intent was not to prohibit them from having a business sign so that someone could, this is the X psilocybin service center.
Okay.
They would be able to have a business sign, but it wouldn't allow them to advertise specific products like
Okay.
Different brands of psilocybin or different, that type of thing. But the overall business sign would be allowed.
Okay, that answers my question.
Yeah, thank you, Chair. Just to expand upon Commissioner Mitchell's first question was in regards to restaurants. Yeah, I'm trying to recall maybe some of the rationale and discussion that we had in our work session related to restaurants, because I wouldn't be so concerned with restaurants. Where I would be concerned, it would be restaurants that had liquor licenses and was actually serving liquor. And so that's kind of very consistent with the rest of the regulations. But if it was just a restaurant that wasn't licensed or serving alcohol, then I wouldn't have an issue. So does staff remember it all, or do any of the commissioners, the discussion, was it just restaurants in general? Because again, that doesn't make any sense. Or was it restaurants that also served alcohol, which I think makes a lot more sense?
Well, the state statute does not allow overlap of interior or exterior. And so it specifies restaurants in that. So that's where that came from, is we just expanded that list of businesses that aren't allowed to overlap that provided by the state and said, well, we shouldn't allow them in the same building. So I don't know that there was a lot of thought put into it. You just kind of took the state listed businesses and applied that to not being allowed in the same building. But as Mr. Boone pointed out, you could allow restaurants, but maybe not allow restaurants with OLCC licenses within the same building. You have some flexibility, as long as they don't overlap, because that's the state requirement.
Thank you.
Thank you. Any other questions for staff?
Last question was on the intention to review this in 3 years. Is that, and this may be more appropriate for Mr. Boone, is this a binding obligation to do something within 3 years, or is this just going to be stated, we intend to look at this in 3 years, but in 3 years we'll...
Right, it's not a sunset clause, which would be a binding obligation, because under a sunset clause, it goes away. And I don't think the commission's concept would be that all these time, place, and manner would just go away. So it's an expression of intent by the commission and the council to do so.
Okay, thank you.
Okay, if there aren't any other questions, I think we'll open the public hearing. But as I understand, there are nobody wanting to comment, so then I guess I will close the public hearing and we can move into deliberation. So there's one way we could do this is kind of go down the list there and get a sense of everyone's opinion on it. You can just go ahead and chime in if you want.
All right, I'll start with an easy one. I think we should remove the 1, 2, 3, 4, 5, the fifth bullet that says require all persons present at an administration session to be at least 21 years of age. Since this is already included in the state regulations, I think it's just redundant and that's unnecessary. So my suggestion would be to remove that since it's already included in state regulations.
Yeah, I think if that's true, I would agree. Is that true? Okay, that sounds good. So let's, I think we're all in agreement on that, right? Okay. What about, so the first item, that is, so prohibit the use in residential zones and as a home occupation. Isn't that also in the state?
Well, the issue that came up was the state statute, which is actually the administrative rule, well, it's both the statute and the rule, says it in exclusively residential zones. It uses the word exclusively. And the concern was that if a residential zone allows some other, all our residential zones allow major public facilities by conditional use. Does that mean it's not an exclusively residential zone? You know, so I think we wanted to say that our zones would be prohibited.
Okay. So how does the commission feel about that? Are you all in agreement, or does somebody have, want to take an exception to that, or? Okay, the next one is require 1,000-foot buffer from registered childcare facilities. Okay, so this is one that we added during our work session and requested that it be in our proposal here tonight. So are we all on board with bullet number 2?
I don't want to derail the discussion, but I just want to sort of reiterate my perspective from the last time we spoke about this, that that the state regulations, you know, as we're increasingly seeing, are both stringent and thorough, and I don't think cluttering up our code further is necessary. While it's not a surefire indicator, I think the lack of you know, public urgency we can see here, you know, does not detract from the theme that this is well taken care of. Though I think the work done on this has been of very high quality. I wouldn't support moving forward with any of these suggestions.
Okay, so you're pretty much, just so I understand your position, you're thinking that the state regulations are sufficient?
I think they're sufficient, yes.
Okay, thank you. I guess I would maybe counter that with maybe we don't have testimony tonight because folks have seen that we've added a couple things that they would want. So, you know, that's one way to look at it as well. Okay, so we've heard from Commissioner Rigby on this one. Does anybody else want to have a comment? Commissioner Moreno?
I just have a quick question. Can you remind me again what the asterisk is in some of these?
Oh, these were the code concepts or code regulations that the commission had differing opinions on at the last study session.
Thank you.
Yeah, my question would be, are we actually specifically calling out registered childcare facilities? Is there, so if it was unregistered, that would be okay?
Yes. Yes, because we don't have, so the state requires registration for certain types of childcare facilities, but not all types of childcare facilities. So for instance, of my recollection, if I'm remembering this right, if you care for 3 or fewer children, you're not required to be registered or have a license. The only way we can track it is through the state registry. So if there's unlicensed facilities out there, we're not going to know.
I think the other point is a prospective business owner wouldn't be able to know when they're making their selection of where they're going to locate either. So.
Thank you.
Okay. So are we I guess with the exception of Commissioner Rigby, are we okay with the second one or not? Or I guess we're kind of doing a straw poll here as we go, but and in the end kind of come up with a recommendation, but just maybe get a sense. Okay. For now, let's move on to the next one. This triggered some discussion, and Commissioner Mitchell, this might be time to jump in and expound on your discussion about the restaurants.
Sure. I guess I expounded on the wrong version of where we were, so I don't need to do it again. I would take out restaurants from this. It's an interesting distinction, though, that Commissioner Heap brought up with the distinction between restaurants that have liquor license or don't have liquor licenses, because my line of thinking really was the vast majority of strip malls have some restaurant, and this is anecdotal evidence just based on me walking around, and I don't want to, with this restriction in here, I think it would make it virtually impossible to find a site that actually fits the regulation. So I felt the concern of restaurant, why having service centers around restaurants, I couldn't find a real rationale for it, though the state having it in there with overlapping walls. I didn't read the legislative history of the state enactment, so I can't really speak to why they did it. I probably should have, but I still don't understand being next to a restaurant. So for our sake, I would want to take out restaurants either altogether, or I think Attorney Boone had said it, maybe take it out and then have a smaller restriction, not just the same building, maybe have like 50 feet or something.
Yeah, and I was going to ask you exactly that, is what do you think about a buffer? Maybe it can be in the same building, but maybe it's 100 feet or 200 feet away, something like that. I mean, would that help?
Sure, that would help. I think my default position is restaurants should be removed entirely.
Got it.
But if we wanted some sort of compromise where it's not removed entirely, it's just dealt with differently and have a sort of a buffer of 50 feet as for the number we're throwing out here, then certainly, I think that's better from my perspective, but.
Chair Stewart, if I may, I don't know the specific reason why the state has required or prohibited restaurants to overlap. My guess is because the consumption is through edible consumption, the possibility of mixing with food or the opportunity to mix that with food is they probably want to keep that separated, and why you wouldn't have it. So that would be my assumption. I don't know that that's entirely true, but that's my guess.
Mm-hmm. What about keeping that same overlapping the concept, maybe like the same concept, like in the strip mall, for example, it can't be the business right next door to a restaurant, but it could be the business between them, the business over there.
So
non-overlapping, however we artfully phrase that, because I'm not artfully
A
phrasing it.
but, for instance.
Or something about, saying OLCC licensed facility could be an alternative.
That's already in there. The businesses with liquor licenses?
It is in there.
Thanks, Chair. I was going to say, I do concur somewhat with Commissioner Mitchell that, restaurants by themselves, it doesn't make a lot of sense, although I appreciate staff's comment that does make some sense about, maybe blending them in with other edible consumption or whatever. But still, I don't see the restaurants making a lot of sense. However, again, if we qualify it to say, I was thinking 75 feet would be pretty close. I was thinking maybe like 3 to 5 stores away, an average size of about 100 feet or less. So I was thinking like a 500 feet buffer, and then also qualify it with restaurants that have a liquor license and serving alcohol. That makes a lot of sense to me. So to kind of meet in the middle, I would say 500-foot buffer and add also the liquor license. Specifically for restaurants, and I think that's where I was differing, because I think we do have that covered specifically for, just individual liquor establishments, but restaurants that are serving alcohol, combining that, in close proximity with psilocybin, I think that doesn't make a lot of sense. So 500 feet and restaurants with liquor license.
So,
Sorry, go ahead.
I'm just trying to, so I'm clear, because you lost me there a little bit. So are you saying 500 feet for restaurants with liquor licenses and then a different regulation for other restaurants, or?
Yeah, no, just, if it's just a plain restaurant, I don't think I would have a buffer. Although it does make some sense, but I don't think it, I kind of agree with Commissioner Mitchell that the restaurant by itself, I don't see maybe the concern. But, you know, if it's specifically a restaurant that's serving alcohol, then yeah, separate it by 500 feet.
Am I correct that if we did it that way, the state regulation on not abutting would still apply to a non-liquor licensed restaurant,
Yeah, not overlapping.
not overlapping?
Yes.
Is overlapping and abutting essentially the same thing, or no?
No, abutting would be like tenants side by side. Overlapping would mean that somebody's
same
operating a
spot.
food cart inside of the service center, as an example.
So like a sublease within,
Yeah.
I would support Commissioner Heap's recommendation, which is we're effectively taking restaurants out of this entirely. The state regulation would obviously still apply, but that's not touching. That just means with inside it, like a food cart with inside it, et cetera. So in theory, you could have a non-liquor licensed restaurant right next to a service center with the way we're talking. And then the liquor licensed businesses will be taken out from this same building restriction and have its own separate 500-foot restriction. So it can, in theory, could be in the same building as long as it's more than 500 feet away.
Okay, and it'd be all OLCC licensed, so liquor stores, restaurants with licenses, okay.
do we have any discussion on any of the other uses listed here? Marijuana businesses,
What?
businesses with liquor licenses, healthcare facilities?
Yeah, just another point of clarification. I remember when we had our work sessions, I was concerned with the insurance requirement. So I think staff stated tonight that that's outside of Chapter 50 or Community Development Code. I know it's listed here, but yeah, I'm okay with the insurance as like a recommendation outside of our Community Development Code, the way staff has been proposing it.
That actually raises a question. Are we actually going to be making two motions then? Or do we make one motion and then you sort of,
You're going to be eventually making two motions.
okay.
At this point, you're giving direction to staff as to what to put in.
Right.
And
I
then
mean,
we'll
I'm just kind of jumping ahead. I
Right.
know.
We'll separate it out, and then, yes,
Okay.
you need to move the land use matter. That you
Yes.
have to do,
Yes,
in the informal part.
okay, all
And
right.
I just wanted to, for reference, so this buffer shows a 1,000-foot buffer, so the 500-foot buffer would be about half of that. So I just want you to be aware of the magnitude of that buffer and, you know, in considering that last regulation.
It's a very good point because, you know, if you're following my logic about basically eliminating the ability to do it in these very few spots, adding another 500 buffer around liquor licensed businesses would further reduce this. That said, I would support the compromise to me, if that's what we want to go.
And just to follow on to Commissioner Mitchell's comments, I think it would only be impactful to those circles that actually contained restaurants with liquor licenses. And how many of those are there? I don't think it's going to be that many. So
Yeah.
probably all of them that we have, I would suspect just by saying restaurants are included, it's permissible, the vast majority of those would be fine.
Yeah.
Well, that and a lot of them are downtown, and downtown's kind of off the table, at least as presented.
Well, like the Oswego Grill here,
That's what I was thinking.
that has a liquor license. I am pretty certain that there are a number, excuse me. There are a number of businesses, darn it, in the MC zone that have liquor licenses as well. I'm just providing this as reference. Of course, you make your own decision, but
Oswego Grill is a good point because Oswego Grill is a standalone building. So if we had gone with the prior recommendation, it wouldn't have, the prohibition wouldn't have applied because it doesn't share it with Oswego. But if we're going to do just a 500-foot buffer, then we've actually restricted a little bit more, not to get too granular nuanced here in statutory text.
Well, and there's other restaurants in that plaza
Yeah,
that
Killer
kind of
Burger,
surround there
yeah.
too, that I think might have, I mean, I think even Chipotle might.
A liquor license?
I don't think they serve alcohol.
Okay, I might be thinking of another one then.
Killer Burger has booze?
My comment would be more power to it. I meant, why do you want to mix psilocybin with places that are serving alcohol? And that's the intent of what we're trying to, recommend here, at least my recommendation. So I think that makes sense.
Could we jump back to the list?
Yes,
Sorry, I don't have a photographic memory, so. All right. Let's keep going. We can always come back to that one if further discussion is warranted. All right, we took out the 21 years of age. All right, what require clients to be released to a sober adult after an administration session? That makes sense. How do you? Okay. Prohibit clients from bringing or possessing weapons. I think that's understandable. Right. Advertisements. We had a little bit of discussion about that. How do folks feel about the statement on advertising, second from the bottom?
I know I spoke on it. I think I'm comfortable with the use of the word products because that's really what we want to restrict, and we didn't want to just restrict this is a psilocybin service center, right? So I'm comfortable with the use of the word products.
I had asked about what this signage, what the code was on signage, and if we do have code enforcement. And I don't know if we were gonna revisit that and find out what the rules are now. Because if you already have rules on signage, then we probably don't even need to go over this.
Well, it would be a non-land use regulation because our sign code is separate from, I had to think about that, separate from Chapter 50. So this would be included in the non-land use ordinance portion, and we could amend our sign code to include this restriction. And we should probably ought to provide a cross-reference within the CDC so folks are aware of it as well, which we could do. But yeah, this would most likely be in the, we could locate it in the sign code portion of the code.
To your question, you're saying, well, we regulate signage anyway, so why would we need to? This is getting to the content of the signage, and our sign code does not regulate content. So at this point, then there's a federal prohibition, I think, on the alcohol, on the tobacco side of things. So that's why it would be going above and beyond, because the federal government, of course, doesn't address it. Okay.
So our sign code's primarily dimensional.
Our sign code really is dimensional and aesthetic. It doesn't get into the content. Well, it uses the word such as,
Yes.
but it really, such as real estate signs, or, something like that. But when you actually look at it, because it's been litigated, it does not regulate the content.
So we couldn't then put that in Chapter
Well,
47.
no, you would put it in Chapter 47. This would be kind of like the first content prohibition that we're going to have because of its, and why? Well, because of the compelling nature, because this is a free speech kind of issue. So you need to have compelling, it's strictly construed, strictly applied, a compelling nature, a compelling obligation to regulate it because of the fact that it would appeal to minors. That's where we're making a finding of that. I personally don't think we're going to get, I'm not too worried about it because I don't think we're going to get much challenge on it because I don't think there are psilocybin products that are going to be advertised. Certainly not like marijuana, because there you're buying those retail and you take them out. Here I have no idea what particular product my doctor has in his center. I just go in and get the prescription, and prescribe it. And here you're being administered on the site, so you're not mixing and matching and saying, well, choose Maui Wowie versus that. And that you would do on the site, not saying we're a proud sponsor of Maui Wowie. So I don't think it's a big deal, but that's where we'd have to put it if you're going to do it.
I'm curious to know what the rules are right now, like on advertising alcohol and tobacco and all of these things that we can compare this to. We don't have marijuana businesses, so, right?
Yeah, as Mr. Boone pointed out, so there, I'm sure, are federal regulations with regards to advertising cigarettes and alcohol.
Yeah.
But in general,
And state
state.
regulations. So we don't, you know.
Yeah, so we don't have any of specific regulations in the code. We just have size restrictions. So if you have a window sign, it can't exceed a certain size and square footage, and you can't have a total of a certain cumulative square footage on a business or per window. So we do have those regulations, but they're really just dimensional standards and
Okay.
number.
Just going to share my thoughts. So I actually like it the way it is. And again, this is outside Chapter 50 of our Community Development Code. But I like it. The only thing is, my concern is what Attorney Boone was saying, was like, we're assuming that nobody's going to say they have a First Amendment concern, and that as we're regulating the content, they're not going to come after. And what a waste of city resources. I think that would be, if we're getting into some First Amendment battle, over this. So I like it, but if there's a chance that somebody's going to litigate, then, I would say just leave it out.
Yeah, and particularly, I think, well, even the land use side, there's nothing that says that once we adopt time, place, and manner restrictions, that we can't adopt new ones in the future. Okay? So if we see it's a problem, you can adopt. Now, there's the concern about, well, what if somebody already has a sign, that sort of thing? We have, so the question is, are they grandfathered? There is a process by which we amortize out signs. We used to allow pole signs, and then we had a process by which the pole signs, was it pole sign? Yeah, by which the pole signs went away. We gave them like 5 years or something like that in order to allow the economic value of that to be consumed. But we're not, so it's not cast in stone.
Okay. And then lastly, we talked about liability insurance. Sounds like we want to keep that in. So let's move to the next one, and then we can kind of go back and sort of summarize where we stand. Oh, that is the next one. Okay. All right, so this is for the production facilities. The first one, prohibit the use in residential zones and as a home occupation. So that's, some of these are going to sound pretty much like the other one. Maybe rather than going through these all individually, let's just, does anybody want to hit on anything in here and make a modification in front of you, Commissioner Heap?
Or just say on the third bullet, we make the restaurant the same as what we did with the service facility, that it has the same restriction as we had previously stated.
I would like to note that production facilities don't allow the consumption of the psilocybin product on the site. So I don't know that it has the same, I guess, danger of someone leaving the site and going to a restaurant.
The danger is more of a potential hazard, safety and production kind of thing.
As a cash-only business, potential of crime, I mean, that could be a consideration. But there's no consumption there. Although they do allow dual license facilities where you could have a service center and a production facility, and the service center portion would still have that restriction.
But my understanding is if you have a dual license, though, you got to follow the more restrictive scenario then, so you'd be subject to service center
Correct.
requirement.
And similarly, with the 1,000-foot buffer between psilocybin production and other service centers or production facilities, that is not just, it's only the 1,000-foot, the cities may apply that by statute. It just says you can if you want to for service centers. It doesn't have that same provision for production facilities, so the commission should discuss why it would be a necessary and reasonable regulation to also have that separation from production facilities. So I just wanted to point that out too.
Okay, thank you. So Commissioner Mitchell, then Commissioner Heap.
Forgive me, I don't remember if we discussed and what the outcome was of, you know, the waste or the byproduct that's made in the production, because it seems to me, to Commissioner Heap's point, and to your point, Jessica, like the service, production facility is not, there's not people using the services, right? So some of the same concerns that we articulated for the restrictions that we're imposing arguably don't apply to a production facility, but something a production facility may have that a service center doesn't is waste from producing it. I don't remember what that discussion looked like.
The OHA rules do have specific and comprehensive regulations for waste management for production facilities. And I would need to search through this giant volume here to find it, which I'm happy to do if you want to continue your discussion.
Well, while you're doing that, I would just, the recommendation is that these only be allowed in industrial and industrial park zones. So you have less sensitive businesses there.
Yeah, that's one of my concern is there's the waste management. Is there a reason to not have it next to any of these other items? But to Mr. Boone's point, it's very, very rare that it would be because it's an industrial zone.
And if I recall correctly, most sort of intense production methods were not allowed under the state regulations, including like harsher solvents and that sort of thing. Otherwise the waste products would presumably be something like, mulch.
Under OAR 333-333-8000, waste management. A manufacturer, service center, or laboratory licensee must store, manage, and dispose of solid and liquid wastes generated during production and processing of psilocybin products in accordance with applicable state and local laws, which may include but are not limited to, and then it talks about solid waste requirements per different statutes, hazardous waste requirements per different statutes, wastewater requirements per different statutes, storing psilocybin waste in a locked waste receptacle or limited access area in possession and under the control of the licensee. If a licensee generated the waste after harvest or process lot has been recorded, or if the waste was previously designated as a finished psilocybin product, the licensee must document a reason for the waste in the psilocybin tracking system, the exact time and method of destruction in the psilocybin tracking system. I mean, it goes on and on. And I do believe as part of the security that they also have to have security cameras that cover where the waste receptacles are located as well.
So on bullet point 3, do we share the same concerns for each item? Do we share the same concerns about a marijuana business? Do we share the same concerns about a business with a liquor license? At licensed healthcare facility, I guess I sort of see because they have their own sort of waste, strict waste protocol. I could see like maybe you want to keep that in, and obviously residences, but I don't know. I guess I'm opening it to everyone else here.
I was just going to expand on Commissioner Mitchell's comments. Yeah, I guess look at the restaurants. I really don't have a concern then with the production facilities. I guess I'm okay with leaving it, but I don't see a strong rationale for why we would have to prohibit facilities from being in the same building as restaurants for this. So the other ones I think do make sense.
Commissioner Moreno?
On bullet point number 3, the last word residences, does that need to be in there? Aren't residences already covered in the first one? It's just a small detail, but
In the first one, what?
in the first bullet point.
This would cover mixed uses.
I think it's there,
Well,
yeah, it's there because of mixed use. So,
Correct.
like, if you have a building that's got
Okay.
commercial and a residential above, that's not in a residential zone. All right, any commissioners have any more comments on the production facilities? If not, let's talk briefly about the 3-year check-in before we summarize. Any comments on the 3-year check-in? Is it we want to keep it in, take it out? Okay, I think we're going to keep it in. All right, so then I guess can you summarize where we're at? Your notes are probably better than mine.
For service centers, first bullet point, prohibiting the use in residential zones, you would keep as drafted. Under the second bullet item, requiring a 1,000-foot buffer from childcare facilities and between other psilocybin service centers or production facilities, you would keep that as drafted. For bullet point number 3, prohibit these listed businesses as being in the same building except for delete restaurants and separate out all businesses with liquor licenses, which would be required to be at least 500 feet away from the psilocybin service center, excuse me. The fourth bullet, require clients to be released to a sober adult, keep as drafted. Delete the drafted draft code amendment requiring all persons present at the administration session to be at least 21 years of age, because this is already covered by the state statute or the OHA regulations. The next bullet, prohibit clients from bringing or possessing weapons, keep as drafted. I do not know what you arrived on with the advertising, so I'd like to hear more discussion from the commission or direction on that. And then the last is keep the requirement for liability insurance as drafted.
Okay, let's pause there. I believe we settled on, at least for the motion, I believe we settled on out, didn't we? Yes,
Sorry, may I make
yes,
a
please.
suggestion? Can we take another straw poll? Because I wasn't clear, so I think we should take another straw poll
yeah.
on this, just to get people's
So,
feedback.
so the question would be to
Yeah.
keep it as is or take it out.
Are we talking about the advertising bullet point?
Yeah, bullet 4. 1, 2,
All right, let's
Second to the
4,
last
5.
bullet.
let's start this way.
Second to last.
Are we just talking about the
Yeah, we're just
advertisement?
Yeah, we're just talking about, yeah. So for the advertisement bullet point, do we keep it in or take it out?
I say we remove it.
Okay.
That'd be for removing it, and main concern is, again, any potential First Amendment litigation, and then the fact that if we discover a problem, we could always add it later. So my suggestion is to remove it.
Yeah, that makes sense to me. I would say remove it.
Well, though I was the one that initially raised and was skeptical, I would be fine leaving it because to me, there's a distinction between the products, which would be banned, but not advertising the business, which was my concern. So I would be in favor of leaving it in.
I'd be in favor of removing it.
All right, so there we are. And then I can continue on.
And just as a matter of clarification, we're talking about service centers right now.
Service centers right now, yes.
You want me to move on?
Yes, yes,
Okay.
please. Yeah, and we kept the liability insurance in, so, yeah.
For regulations for production facilities, first bullet point, prohibit use in residential zones and as a home occupation, keep as drafted. Requiring a 1,000-foot buffer from registered childcare facilities and between other psilocybin service centers or production facilities. it was unclear to me what you arrived at on that. I think the question was whether to require a 1,000-foot buffer from production facilities from other service centers or production facilities, although I think the childcare facilities seemed acceptable to the commission. Third bullet point, same as the last one. Well, actually, take that back. I think you just removed restaurants altogether.
That's correct.
Yes. And then bullet point 4, keep, and 5, keep as is.
Sounds right. Does that sound right, or?
Just to note again, I would be more in favor of removing the require liability insurance because it's outside the scope of Chapter 50 of the CDC. But I understand we're making a recommendation on things that are outside the development code. So, okay.
Well, I think I think what we talked about is we're going to make sort of separate motions. And,
Okay.
and one's a recommendation of council like we typically do. The other one would be more of just like an
Advisory.
informal, this is what you should do kind of thing. Commissioner Mitchell?
On bullet point 2, when we say other service centers or production facilities, I assume there's an exception if it's a dual license, like service center and production facility. I think I just want to make that clear, right? So,
Yes.
yeah.
We could make that exception if you didn't want that. Or, well,
But I think if it's a combined one, they have to comply with both.
so they,
They would have to comply with the more restrictive requirement.
Oh, yeah. My question was, if you have a combined one, then they are treated as one, and it's not,
Yes.
you're not saying they need to be 1,000 feet from the service center because it's treated as one, it's the same one.
yeah, my apologies, yes.
And then, okay, then lastly, we want to keep the 3-year check-in, and again, that's probably more of that's not really the land use part, right?
Right. So I just want to be crystal clear, I'm so sorry, but for production facilities, bullet point number 2, you want to keep as is. Is that correct?
Yes.
Okay.
Yes. I think the idea there was we sort of piggybacked registered childcare facilities with schools and service centers, and if the same regulation is there for production facilities for schools, then we would do that for childcare.
Right, but
as
what
well.
is the rationale for requiring a 1,000-foot separation of production facilities from another production facility or another
Well,
service center?
I mean, and just to be clear, the state does not have a 1,000-foot buffer from schools
Oh,
for production facilities.
Correct.
all right, I'll walk that back then. Well, I guess let me ask the question again then. So the second bullet point, are we good to keep that or remove it? Commissioner Heap?
I'm good with it. I think it makes sense from a registered childcare facilities perspective to try to ensure, the safest type of environment for registered childcare facilities. So I'm okay keeping it.
Why would this one be different from the service centers and schools be excluded?
The
I think,
use,
yeah, I think
the use of the product versus not using the product.
Because in a production facility, there aren't customers using the product.
Right, so then why include childcare facilities?
That's the question.
I think from my perspective, Deanna, the safety could be the rationale, right? All cash business safety, and I assume the production facility would work the same way. And so when we had the police commissioner testify, that was one of the things that stuck with me, which is why I would keep it.
Right, and I think, in my mind, I'm thinking kids are kids, schools and childcare facilities, but.
Well, I think what Mr. Boone was saying, though, is that this 1,000-foot buffer is not currently required for schools
Right,
like it is the other one, but we're requiring it for childcare facilities on
right, and that's my question, what's the difference? So why wouldn't we treat schools and childcare facilities the same?
Yeah, I think, just my opinion is, and I appreciate the comments from the commissioner, but if you go back and you look at some of the most recent history that we have, especially like with things, and I know it's different, but with like fentanyl, and you see where it's been like accidentally spilled or there's been some type of mishap, it's like the younger children I don't think are as aware as the school children are, and you had like baby suffering effects from that type of stuff. So again, I think in the interest of safety, to try to keep it well away from childcare facilities, you know, where you have younger children associated with it, I think it's just safer to do that. That's my opinion.
Oh, I agree. I agree that we should protect kids in general.
I think I failed to understand the distinction that the state laws didn't have the 1,000-foot buffer for schools with production facilities. So now that I understand that distinction, I'd probably expand this to include that with the 1,000-foot buffer here, not just registered childcare facilities, but all schools.
And I apologize, if you actually read the amendments, it does include the schools, and I missed it in my presentation.
does?
Yes,
Oh,
I'm so
okay.
sorry. So the
Okay.
draft
No worries.
amendments for psilocybin production requires a 1,000-foot buffer to schools, the same as service centers, as well as childcare facilities, and to any other psilocybin production or psilocybin service center. But none of those buffers are required by the state for production facilities.
Okay, so it sounds like we want to keep it then, well, most of us. Right? You take a straw poll or?
Just to clarify, under the state rules, the 1,000-foot buffer for schools applies both to service centers and production facilities, or it does not apply to production
It
facilities?
only applies to service centers.
So
Yeah.
we, at some point during our work sessions, we requested to add this.
We requested to add registered child facilities when we were talking about service centers because we thought that was a gap. Why protect 15-year-olds and not protect 5-year-olds, which I totally agree with.
That was a conversation.
And now we're talking about production facilities, which I personally didn't realize the state didn't have the same restriction for 15-year-olds in other schools. So I agree we add registered childcare facilities, but I also think we should then add schools
Well, I think-
because the state doesn't have the same thing.
Yeah, I think we are.
Is that
That's
where everyone
we
is?
Landed, yeah.
And now, it was pointed out at the study session that the statutory 1,000-foot buffer does not apply to manufacturing and production facilities.
No, that was me just not
was
reading
nuanced,
correctly.
yeah.
Yeah. So we're going to expand this because right now the bullet point doesn't say, it needs to say registered child facilities
We're
and
gonna,
schools.
we're gonna put it in our, potentially in our motion.
Yeah, but if you read the actual draft amendments, it is included in there. So that's my mistake. I missed it in the
Got it.
presentation.
Page 8.
Yes, page 8.
All right, any other discussion on production facilities? There's one more thing I think we should talk about before I'll ask for a motion, and that is going back to Commissioner Leek's email, does any commissioner have any interest in limiting the number of first 3 years or whatever it was?
I was going to say, I think the number that was given of 5 is just too high. I don't think we would have 5, and it's not going to really be material in regulating if it's 5. If we really want to go after that and say, you know what, it makes sense to introduce this slowly, I would be more comfortable with a number of like 2, but 5, to me, we might as well just leave it out.
Yeah, I feel like it's going to slowly evolve of its own volition.
I think we have enough buffers to limit that number.
Yeah, we may. Okay, any other discussion? If not, I think we've sort of packaged together a possible motion. Would anybody like to put that forward?
This motion could be just to direct staff to prepare code amendments as discussed, and because Jessica has the notes on your parts, and obviously when we come back, then that's the formal motion, and you've got it separated out. Okay. So,
Got it.
So I'd like to make a motion to approve the psilocybin regulations for production and for service facilities as discussed with staff tonight, to have staff go off and prepare a preliminary set of findings, and then have the commission come back and review those and approve them at the next meeting.
Okay, I have a motion. Is there a second?
Second.
Okay, I have a motion and a second. Is there any discussion before we vote? Seeing or hearing none. Iris, will you please call the roll?
Stewart,
Yes.
Heap,
Yes?
Mitchell,
Yes.
Moreno,
Yes.
Rigby.
No.
Okay, motion carries 4-1. Thank you, everybody, for your discussion.
This will be brought back at the next meeting. What's your schedule on this, Jessica?
Lord, I should have that ready. That would be on. Eric, can you confirm? Thank you. June 26th, 6:30
Next
PM?
meeting, 6:30.
Yes, that meeting will be remote.
All right, moving on in the agenda to other business. Is there any other business that any members of the commission have or staff? Not, let's move into schedule review.
All right, well, I actually have some business as well as schedule review, but it's good that we save it till after schedule review. But in terms of the schedule coming up for our next meeting, as we just talked about, it will be a remote meeting to consider findings, conclusions, and order for the psilocybin time, place, and manner regulations. On the 10th of July, our meeting will be sort of oriented around a presentation from somebody at Metro, Molly McCooney-Mesker, as well as somebody here in our engineering department, Will Farley, and they're going to give us an update on the regional transportation plan. We'll also be hearing an update on policy related to electric vehicle charging from Amanda Watson, who's our sustainability program manager here at the city. So 2 presentations that day on the 10th of July, as well as on the 24th. There will be a sort of work session on, or an update really, on the climate-friendly equitable communities parking regulations. So there's a lot to think about that we'll be chewing on in the month of July here coming up. I also wanted to mention that we did have some resignations from the Planning Commission, and Commissioner Heap, I'm not sure if you want to sort of say anything on your own, but we did have some resignations, and one of them was Rob Heap here, Commissioner Heap on the commission. So this will be his last meeting in person. And, you know, I don't know if there's anything that you want to say, just to give it in your own words, I suppose.
Thank you. So I'd just like to thank everyone, all the commissioners that I've had the opportunity to serve with on the Plan Commission, and the staff. I think everybody's done an excellent job. And I think one thing that's really great about the commission is that we have such a large diversity of views. And then, you know, you see the commission really evolving over time, and just, you know, more people getting involved. So I think that's great. And I really look forward to the next commission for new members getting on board and getting new ideas. And again, thanks to everyone. It was really a pleasure serving with everybody on the Plan Commission. So thank you.
And thank you for your service, absolutely.
Yeah, thank you so much, Commissioner Heap, former Chair Heap, of course. It was a long time until I actually remembered to stop calling you Chair. But we just want to acknowledge your service here, of course, and we have some items for you that I'll bring over in just a moment, but I just wanted to say, you know, an official farewell. You've been on the Planning Commission since 2015, so it's a considerable amount of time, you know, going on 8 years here. I've only been around since 2019, so about half of your tenure here. But, you know, while I've been here, you've been involved in some really significant projects, at least the sort of review and consideration of those projects, such as the Middle Housing Code amendments, housing needs analysis still ongoing, of course, the definition of demolition project to redefine demolition, the rezoning for the Boones Ferry Road Affordable Housing Project, short-term rental regulations, now, of course, psilocybin time, place, and manner regulations, numerous annual CDC amendments, R6 structure design amendments. That's just in the last 4 years. There's so much that I could list that I'm leaving out. So it's really a substantial body of work that you've left behind here. So really just want you to know how much you're appreciated and how much we really appreciate your ongoing, 8 years of service here. So you will be missed, and we have some items for you to commemorate your last day of being an in-person commissioner.
Thank you. Thank you for the kind words. Thank you. So much. Thank you. Thank you very much. Wonderful gifts. Thank you.
So that was the other business, I suppose, that we had this evening. Yeah, and I wanted to mention that we did, formally receive a resignation notice from Commissioner Phillips as well. So next meeting, the remote meeting, will be his last day with the commission. So just a few announcements to mention here, and just also want to mention that we will have new commissioners coming on board at our meeting on July 10th, and we'll need to vote for a chair and vice chair at that point. So we'll have some new folks in the commission, but it's unfortunate to see others go, and just want to, again, thank you for your service here. And that's all I had.
All right, thank you. And with that, I believe we are adjourned.